The department is one arm of the Justice Ministry whose services many Jamaicans have to use. Corporate Affairs Manager at the department, Stacey Ann Christmas, explains the purpose of the organization.
The Administrator General's Department was set up by statute, the Administrator General's Act, and what the Act really empowers us to do is to administer estates and trust funds. What that really means is that someone were to die either without a will, or they have a will and haven't named an executor, or they have a no will, which is the case usually in Jamaica. The Administrator General has the power to apply for what we call a grant of administration. That gives her the authority to collect all the assets of the estate, pay any debts that the person may have left behind, and then distribute to whoever the beneficiaries might be in that estate.
It's important to note that adult beneficiaries of an estate can proceed to claim their benefits through the use of private attorneys. However, minors are not at liberty to do so.
Where there's a minor as a beneficiary in an estate, the Administrator General is the proper person to make the application. You would have to get a court order to the contrary to administer an estate like that. So once there's a minor, we are the persons who are going to administer it. For obvious reasons, the minor cannot protect their own interest, and we are here to protect the interest of that minor. If there are no minors in the estate, what the person would do is to go to a private attorney at law of their choice and report the matter to them. The attorney would apply to us for permission to go ahead. And once all is in order, we will look at the application and give them a certificate from the Administrator General saying that they can go ahead.
In the event someone dies without a will and his or her descendants wish to claim property left behind, there are several steps which must be followed in order to obtain same through the Administrator General's department. Firstly, a form must be completed which will provide a declaration of the person's assets, as well as proof of the relationship between the deceased and the person or persons claiming to be beneficiaries.
From that process, we look at it to see, are there children, are there only adults who are beneficiaries? If they're children, we're going to accept it, we're going to ask for proof of death. That's often a stumbling block in our process of administration because the beneficiaries sometimes don't have the proof of death. It could be a death certificate or it could be an affidavit in proof of death. So a person should come with those documents. Come with proof of the relationship of the persons who are claiming to be beneficiaries. So say your father has died, you need to come with your birth certificate with his name on the birth certificate. If that's not possible, what you need to do is to go to the courts and get a declaration of paternity, and that will suffice. Or if you are what we call common law spouse, you also have to go to the courts and get a declaration of spouseship, because you have to prove your relationship, because it's your relationship that gives you an entitlement. So we have to ensure that you're the proper person to benefit from the estate.
And the process does not stop there.
Thereafter, what we will do, we'll seek to have some investigations into the person's asset. You would provide us with a little information. Say you think the person had an account at NCB, Scotia, wherever it is, whichever financial institution. We're going to investigate that. Once all is in order, we then do an application to the courts for a grant of administration. If the estate is valued over 1.5 million, we would go to the Supreme Court, and if not, we would go to the Resident Magistrates Court if it's below the 1.5 million. Once we get the grant, we will then move to do a notice to the creditors, because your debts follow you through even after you have died. So we have to satisfy all the debts that you have left behind. Funeral expenses and whatever other thing you have left behind, administrative expenses, and then we'll move to distribute to the beneficiaries. So that's what we do here. If it is that it's not an estate we're going to administer, say they're all adult beneficiaries and they can go ahead, the private attorney would do a similar activity.
This process can last 40 or more weeks before distribution takes place. However, steps are now being taken to reduce that period. It must be borne in mind, though, that even up to the point where assets become available for distribution, if there are minors involved, they must attain adulthood before they can profit from the full benefits.